for over 20 years. He's been a very good friend of the real estate industry, representing realtors and real estate agents in defense of claims over that time period. He is a partner at Almanza, Blackburn, Dickey, and Mitchell. He also serves on the TREC Broker Lawyer Committee and has a history of working closely with that agency on forms and other issues. Most recently, he began Seller Shield. Those of you on here probably have heard of it and use of it. That is a new tool that he will probably talk about a little bit later, but allows you, the agents, to get out of the seller's disclosure business and leave that where it should be with the seller. We do license all of our disclosure forms to Seller Shield so that you all can provide that access to your clients, your seller clients, for that purpose. We are discussing seller's disclosure today. I've asked Bo to leave some time at the end to address specific issues related to COVID-19 and disclosure. I will assist with that as well. But with that, I'm going to turn it over to if I can say your name, Bo Blackburn, and thank you for being here today.
It's my pleasure to be here. Thank you for giving me the opportunity to present. This is actually one of my very favorite things to do, is get to interact with real estate agents and have frank conversations with them about lawsuit and lawsuit prevention. Sounds kind of dorky, but I can assure you it's way better than me sitting in a deposition all day. So I love the opportunity to get to interact with folks. This is, to be frank, this is my first webinar like this. So I hope that I can deliver the value through this medium. I think I can, but we're gonna kind of stumble through it together and hopefully learn how to do this, because I do think this may be more of our future, doing stuff like this rather than maybe the old way that we did it. But before I jump in, I want to say a little bit about myself. And, you know, disclosure here, I'm a lawyer. So when I say I'm a little bit about myself, that means I'm going to say a lot about myself, because I can't help it. I'm a lawyer. I spent the first 2 years of my career as a prosecutor in Midland, Texas. A lot of folks, not me, of course, but a lot of folks would say that prepared me well for my career in representing real estate agents. See, this is normally when I get agents to laugh at me, but probably no interaction here. But no, I'm joking. I loved my first 2 years as a prosecutor in Midland. After doing that, I moved to the firm that I'm at now, Almanza, Blackburn, Dickey, and Mitchell. I started with that firm in May of 2000. And I'm still there. In the last, almost 20 years now, really close to 20 years. I'm almost at my 20-year anniversary with the firm. I have spent the vast majority of my time representing real estate brokers and agents and sellers of residential real estate in claims related to real estate sales. I do that in Austin. Obviously, I'm physically located in Austin, but I've had the real pleasure of representing agents and brokers across the state of Texas, including, you know, all the way down to Laredo, all the way west to El Paso, all the way north to Amarillo, obviously Dallas, Houston, San Antonio as well. So I've had a lot of experience in helping agents and brokers. And the reason that I start with that is what I try to do anytime I teach is take the lessons that I've seen my clients learn the hard way. And when I say the hard way, what I mean is that they've had to struggle through a lawsuit, and then try to take those lessons and teach them to other agents and brokers so they don't have to have that same experience. They can avoid that pain of going through a lawsuit. So that's what I'm going to do today. At a high level, I'm going to talk to you about some general things that we've learned over the years about how to avoid lawsuits. And in a nutshell, that's what we're going to do. The only other thing I'll touch on a couple other things. My service on the Broker Lawyer Committee, and then my just general connectedness to your industry so you can understand where I'm coming from. I have had the distinct pleasure of serving on the Broker Lawyer Committee. I think I'm on year 7, I think. It kind of goes fast. I love serving on the broker lawyer committee. I get way more out of it than I put into it. It's a way to understand what's going on in the industry. I get my finger on the pulse of the industry in a way that I would not otherwise. For those of you who don't know a whole lot about our committee, just very briefly, our committee is comprised of 6 brokers throughout the state and 6 lawyers. And then we have 1 at-large seat that's appointed by the governor, who's not a broker and not a lawyer. I think a lot of people forget that there's 6 brokers on the committee as well as 6 lawyers. So we have even representation on the committee. And our general task is to promulgate forms that you as agents use in your transactions. And our charge is to do that in a way that they are user-friendly. In other words, that laymen can use, that you don't necessarily have to have a lawyer to review the form, and then to update them based on current events. And that's our general charge. We meet at least 2 or 3 times a year, depending on the circumstances. When there's legislative changes, obviously we meet more than that. But it's a great committee. I love our committee. We, I think, have a good process. Very happy with how we do things. One real quick plug about our committee. We do not, except in the case of an emergency, we do not make any new forms or change any existing forms without an opportunity for what I call the community. And what I mean by that is agents, brokers, trade associations, and other members of our community, title, lenders, etc. We publish anything we're thinking about doing well in advance of doing it, and we give the community an opportunity to comment. Then we schedule another meeting and we go back and we review every single comment that anybody submits to us regarding what we're thinking about doing. And frankly, many times that saves us from making a mistake. A great example I always like to use is for those of you who remember when TRID was coming out, all the changes related to TRID. My committee proposed a change to the contract that was almost universally hated by the community. Almost every single comment that we got was, "This is a terrible idea. Please don't do this." And as a result of those comments, we decided not to implement the change. And thank goodness that we didn't, because the community was right. It was a bad idea and we did not implement it. So the reason I tell that story is I want to encourage you to be part of our community, pay attention to things that we're proposing, and comment. Because I promise you, we actually read every comment, and that's a chore. I mean, we schedule 2 days sometimes, literally to go through every single comment that we get from the community. So I like to make that plug anytime I get an opportunity to teach. And I think it makes us better as a community. So I would encourage you to pay attention and submit any comments if we're making any changes or new forms. All right, with that said, only last little thing about me, if that doesn't convince you that I'm part of the real estate community, let me try this. My dad is a broker. He's a real estate broker, has been for a long time. And my mom was a licensee for a very short period of time under my dad's brokerage until they decided that that was really not a good idea for their marriage. And she decided no longer to work for my dad. But I live, eat, drink real estate. One more thing. My wife is a general counsel for title companies. So I'm about as connected to the real estate industry as I think I possibly can be. All right, enough about me. Let me kind of jump in. What are we going to do here today? If I can make this thing work. Here we go. We're going to talk about something I call anatomy of a lawsuit. And this is obviously a play on the college anatomy of this, anatomy of that. What we're going to try to do is we're going to break down what a normal residential real estate lawsuit looks like and have a few what I call takeaways. And takeaways are what they sound like. It's something that I want you to take away from what we're talking about, hopefully incorporate it into your practice so you don't ever have to sit down with me and defend a lawsuit. All right, what are we going to talk about? We're going to talk about who are the normal participants in a residential real estate lawsuit. What is the typical factual scenario that we see over and over and over and over again? What are the legal claims that are asserted in that normal factual scenario? What are the important documents? And then what does Bo do and how can I help him? The key part of this is the important documents. If you're going to kind of fall asleep or multitask while you're listening here, zoom in and pay attention on the important documents part. That's, to me, that's the real heart of what we're going to talk about. And then what does Bo do and how can I help him? All right, so let's jump in here. Who are the participants in a normal residential real estate lawsuit? Well, first of all, the seller. The seller is almost always the primary defendant in a residential real estate lawsuit. So who's the plaintiff most of the time? The vast majority of time, it is the buyer who is suing people, and it is the seller who is getting sued. That is our bread and butter. That's 9 out of 10 times we see the buyer bringing the claim and the seller the one being sued. So who else is involved? Well, the number 2 party in terms of frequency is the listing agent and listing brokerage. And I'm probably going to use those terms interchangeably throughout what we're talking about today, agent and broker, because for our purposes, it doesn't matter much today. So the listing agent and the listing broker is the number 2. Let's see if I can get my 2 fingers up here. The number 2 party in a residential real estate lawsuit. So who's number 3? The buyer's agent and the buyer's brokerage are almost always sued as, in a lawsuit, but they're not all the time. And then finally, and kind of a distant 4th, is the real estate inspector. They get sued a lot, but not nearly as much as the seller and the brokers in the transaction. So if we were casting a play or doing a movie, these would be our participants. This would be our cast. You've got the buyer, the seller, the brokerages, and the inspector. All right, what is our normal factual scenario? Actually, I got ahead of myself. I'm going to stay on this one. Let me tell you a bit about what the normal factual scenario is. And it's something like this. You have a transaction, obviously, with the buyer, seller, brokerages, and the inspector. It closes. At some point after closing, the buyer discovers some type of property defect. Something wrong with the property. Could be a roof leak, could be foundation, could be water penetration, could be mold, could be 10 or 15 other things. But the key characteristic of it is it's a property defect that they claim wasn't properly disclosed to them and or wasn't properly discovered in their due diligence. They get mad that it wasn't disclosed and or discovered. They hire a lawyer and they sue the seller, the listing agent, and their own agent and the inspector. And that's your typical factual scenario. That's the factual scenario that I got on my desk when I was a baby lawyer back in June of 2000. That's the factual scenario of the lawsuit that I have sitting on my desk right now. And that's been the factual scenario that I have seen consistently in the last 20 years. And in fact, I barely have to read the petitions now because I know exactly what it's going to say, because it's the same thing over and over and over again, which is kind of sad, really, that in 20 years, we haven't been able to fix this issue. Okay, so we've got, so far, remember we were going to talk about the participants. We're going to talk about the normal factual scenario. So let's pivot and let's talk about the legal claims that are made against the seller and the listing brokerages. Whenever I teach, I always attempt to split my thought process into how does this impact a listing brokerage and how does this impact a buying brokerage, because it's very different. Your risk is very different depending on who you're representing in the transaction. If you remember, who is our number 2 defendant? It's the listing brokerage. If you are a listing agent, your chances of getting sued are higher than if you're representing the buyer. And hopefully here in a couple of minutes, you'll understand why. So these are the claims that are made against the listing broker and the listing agent. And there's 4 of them, and we're not going to spend any time at all getting into the weeds on any of these things. I just need you to understand this at a high level so we can learn what the claims are so we can figure out how to stop them. That's why we're talking about legal claims. I don't expect any of you to understand this other than a high level. So what are the 4 claims? And this is what we see over and over and over again. Fraud is one of them. Fraud in a real estate transaction is another one. And that's a specific statute that I bet most of you didn't realize existed. There is a statute that our legislature passed that is specifically intended to help buyers of residential real estate sue sellers and agents. It's called fraud in a real estate transaction. The next one is negligent misrepresentation. And then finally, DTPA. You've probably all heard of Deceptive Trade Practices Act claims. That's where you may have heard of treble damages, right? You can triple your damages if you're a successful plaintiff under the DTPA. These are the claims that we see over and over and over again. Now, if I could condense all of this stuff that we just talked about into one word, that one word is misrepresentation. In other words, claims that the buyers make against sellers and listing agents and brokers really are about one thing, and that is an allegation that the seller and or the listing agent misrepresented something. Y'all with me? Misrepresentation is the key thing when you're analyzing the legal claim. Let's break that down. Let's take fraud and break down fraud a little bit. Again, not in the weeds at all, but a little bit so you understand what I'm talking about when I say misrepresentation. When a buyer sues under fraud, they have to prove, getting used to my camera here, they have to prove 4 things. Number 1, a material representation that was false. Lori, since I think you're the only one that can actually talk, you're gonna be my guinea pig here, if you don't mind. In layman's terms, what does that sound like to you?
A lie?
Bingo. Thank you. You did it perfectly. That's exactly right. It sounds like a lie. So they're alleging, the buyer is alleging that the seller and or the listing agent lied. What's another word for lying? What's the fancy lawyer word for lying, Lori? It's down at the bottom.
You're putting me on the spot here, Bo.
Misrepresentation.
Misrepresentation.
Right? It's the same thing. Claims against sellers and listing agents, if you boil them down, it's misrepresentation, or in layman's terms, it's exactly like Lori said, it's a lie. And that's really what the claims are about. So let me go back to fraud. The first one is a material representation that was false. That's lawyerese for lying. The second thing that they have to prove is that the seller and listing broker knew it was false or made it recklessly, blah, 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 blah. So that's the second thing that they have to prove. And then the third thing is that by lying, the intent of lying was to induce the buyer to buy the house. And then the fourth thing they have to prove is the buyer relied on the lie. Now that's a lot of words that really can be broken down into misrepresentation. Okay, so what have we done so far? We've casted our play or casted our movie. We know who the participants are. We know what the story is. In other words, A buyer buys a house, they move in, they discover a defect, they get mad that it wasn't disclosed to them by the seller and or the listing agent. And the claim they're going to make is that they were lied to. So we know who are the participants, what are the legal claims, what is the normal factual scenario. Now let's talk about what does Bo do and how can I help Bo? And this is kind of a play on a couple of things. One of my favorite movies is Jerry Maguire. Love that movie. Love the scene where Jerry is very, very frustrated with his client, and he is basically yelling at his client, and he breaks down and he says, "Help me help you." That's what we're doing here. Is I'm telling you, if you do these things in your transactions, it will allow me to help you get out of a lawsuit. So I'm doing a little play here on Jerry Maguire, my friend Jerry Maguire. And then I'm doing a play on, there was a commercial years ago. It was called The Money Tree. And it was a lending commercial. And I don't remember anything about it other than they made a joke in the commercial that the money tree wasn't blooming. So I saw that and I laughed. And anytime my wife or my kids asked me to do something that I didn't want to do, I would say, "I'm sorry, our money tree is not blooming. We can't do that right now." So this little scenario that I'm going to give you to illustrate is from that commercial. So here's our hypothetical. I'm going to give you a hypothetical, and we're doing the hypothetical, and it's dumb. It's a silly hypothetical, but it's silly on purpose. I promise you there's a method to my madness here. So bear with me on the silliness. And here's our hypothetical. And this is, again, to set the scene here. This hypothetical is to illustrate how you can help me help you. All right, with that background, here's the hypothetical. Buyer and seller are at a house. The house is being sold, obviously, from the seller to the buyer. They're in the option period. The only people at the house are the buyer, the seller, and the inspector. During the inspection, the buyer and the seller are sitting in the kitchen table or backyard, whatever. They're sitting around, they're shooting the bull. And at some point, the seller looks at the buyer and says, "Hey, do you know about my money tree? I have this tree in the back and it blooms $5 bills in the fall. And it's one of the coolest things about my property. Love it. You're going to love having it. It's going to be great for you. You're going to be able to go out and pluck $5 bills out of the money tree here in about 6 months when it blooms. You're going to love it. I hate the fact that I'm moving and leaving that thing, want to take it with me, but I can't. It'll die if I take it with me." And the buyer says, "Wow, that sounds pretty cool. Super excited about that." They close. The buyer starts, in the mornings and when the fall rolls around, starts going out in the backyard, looking at the money tree, waiting for it to bloom in anticipation of plucking $5 bills off the money tree. Unfortunately, never blooms. No $5 bills bloom on the money tree. The buyer goes, "That damn seller lied to me. That seller misrepresented to me. I'm going to call my lawyer and I'm going to pursue a claim against that seller for misrepresenting, for fraud in a real estate transaction, negligent misrepresentation, and violations of the DTPA." And he calls the lawyer, and the lawyer says, "You know what? You've got a claim not only against the seller, you know who else you can sue? The brokers. You can also sue the brokers. Let's sue the brokers too. And let's sue that inspector as well." The lawyer gets a demand letter, gets a lawsuit ready, sends it out to the listing agent. And the listing agent happens to be a client of mine and does the right thing, of course, and hires me when the lawsuit comes in. That's always a very smart move. You should always hire me when the lawsuit comes in. Then the thing that happens in every one of my transactions happens. My seller says, "Bo, I didn't do this. Get me out. And I go, okay, here's what we're going to do. I'm going to do blah, 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 blah. Don't worry about the specifics. But I'm going to get in front of the judge quickly. And I'm going to make an argument in front of the judge that gets you out before we have to spend a ton of money on discovery, before we have to go to trial. I'm going to do a motion for summary judgment. You don't need to know what that means. It's just an opportunity to get in front of the judge and say, Judge, let my people go. They do not need to be in this mess. And what I'm going to do is I'm going to get up and I'm going to make an argument regarding why my client needs to be dismissed. And it's going to sound something like this. I'm going to say something to the judge that sounds like the following. Judge, I'm Bo Blackburn, blah, 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 blah. And I represent Blackburn Realty, the listing brokerage in this transaction. Judge, I do not represent the seller. The argument that I'm making has nothing to do with the seller. I'm here today to represent Blackburn Properties and Blackburn Properties only. I'm not saying that there is a claim against the seller. I'm not saying there's not a claim against the seller. I'm here making an argument on behalf of Blackburn Properties only, Judge. And Judge, here's the argument. And it's very simple. The buyer is upset because they were lied to. Okay, let's take them at their word. Let's say they were lied to. Judge, who did the lying? Did my client do the lying? No, Judge. You heard the buyer's lawyer explain that there was a meeting at the property, and Judge, you heard who was present when the lying took place. It was the seller and the inspector. And the inspector wasn't even around when the lying took place. He was off doing something else. And remember, Judge, I represent Blackburn Properties. Blackburn Properties wasn't there. Blackburn Properties said nothing about this money tree. You heard the buyer admit that Blackburn Properties said absolutely nothing about a money tree. Now, were they lied to? I don't know, Judge. I have no idea. And I don't care. It doesn't matter to me. I don't represent the seller. I represent the real estate agent, the listing brokerage, and my listing client did not lie. In fact, they didn't say anything. And I will put up a slide in front of the judge. I'll have this blown up. And I'll say, Judge, let's look at what they have to prove against Blackburn Properties to win. Number one, Judge, they have to prove a material representation that was false. Blackburn Properties didn't say anything, Judge. Nothing. They were silent on this statement about the money tree. So how can they ever prove that Blackburn Properties is liable? Because they can't show the first element that Blackburn Properties lied. And you get the point, right? I'll argue that, and they'll have to show that somehow Blackburn Properties misrepresented. And if they can't, then the judge is going to say, Blackburn, let your people go. You're free. You're out. So that's what I call the money tree argument. Now that sounds simplistic, and I told you it was simplistic. I warned you it was simplistic. We're going to circle back here in a bit, and we're going to do a hypothetical that's way more specific, and we're going to compare the two, and I think you'll see why I made the first one very simplistic. So that's what is a little bit about what does Bo do and how can I help him. Now let's talk about, do this quick. All right. Let's talk about the really, really important part that I left for last. What are the important documents? And the important documents, there's 3 really important documents on the listing perspective. Number one, actually, I'm gonna set this up a little bit before I go through the 3 documents. I want to remind you what we're talking about. We know who our participants are. We know what the normal factual scenario, it is the buyer being upset and mad that they were lied to about a property condition. That's what we see over and over again. That property condition could be a roof, could be foundation, water penetration. Again, doesn't really matter for our purposes. Something that was wrong with the property condition. So there are 3 documents or types of documents that we see that are critically important in every piece of litigation that I do. This is normally where we do some audience participation. And I say, anybody want to guess what those 3 documents are? I don't know. Let's get a little creative here. Can we chat? Are we allowed to chat here, Lori? Let me see. Anybody want to guess what any of those 3 documents are? Bingo. Bingo. You guys already nailed it. Jennifer, Adrian, Leslie, y'all got it. Yes, yes, yes. Y'all are okay. Perfect. Y'all are paying attention. I love it. I love it. This is cool. Bingo. You got it. Seller's disclosure notice is always, always, always one of the most important documents that we see in litigation. And we're going to spend a real amount of time talking about that here shortly, but let's identify what the other 2 documents are. And y'all keep going. I'm going to kind of read out some of the guesses that y'all are making. The listing agreement, important, but that's not what I'm looking for. IABS, important, but not what I'm looking for. Inspection report, again, important. Oh, somebody got it. Jennifer, you got it. Well done. The statements that are made in MLS. That's the second category of documents. I'm sorry, that's the third. I apologize. That's the third category of documents that we're going to talk about. And I'm going to scroll up here to see if I missed anything. I'm glad that y'all are consistent with my teaching, because every time I teach this class, the agents get the first and the third one before they get the second one. In fact, it almost always takes a little bit of time for you guys to get the second. So y'all keep coming in here. What's our second set of documents or document that causes problems when you're representing a seller? I love it that y'all don't get this right away, because it's somewhat comical, but because it is the one set of documents that y'all have the absolute most control over. Okay, we got some guesses coming in. Emails, text, contracts. Nope. Listing agreement. Nope. Come on, guys. Representation disclosure. Nope. Non-realty. Nope. No. Amendments 1 to 4. Oh, here we go. Jennifer, you got the first one and the second one. Well done. I don't know you, Jennifer, but you're paying attention. Well done. Flyers. Max, you got it too. Well done. Okay, let me tell you what I mean by that. I call those agent marketing materials. Agent marketing materials are the second most cited documents for claims that buyers make against the seller and the listing brokerages. So I'm going to sum this up. Number 1 is the seller's disclosure notice, which is by far and away the document that we see the most problems with. Number 2, agent marketing materials. And number 3, statements in the MLS. So let's break those 3 down, because this is the meat of what I want to talk to you about. This is the heart of the presentation, the important documents. Before I jump into those, let me tell you why this is the meat. I think if you know the danger zones in your transaction, then hopefully you'll pay more attention to these areas. And if you can just pay attention to these areas, it will do a ton for you in terms of risk mitigation. So let's break those down. The first one is the seller's disclosure notice. Here's where I like to start with the seller's disclosure notice. I like to tell people, don't think of it as the seller's disclosure notice. Think of it as a different name. I teach agents to think of it as not the seller's disclosure notice, but the seller's representation list. Why do you think I use that word representation? What word have we been talking about that is the source of claims? Misrepresentation. You can't have a misrepresentation without a representation. Where do representations come from regarding property defects? If you think about it, it's pretty dadgum simple. The seller's disclosure notice, or what I call the seller's representation list, is the document that has the most representations about what? What is our buyer mad about? They're mad about a property defect. Where do most representations come from regarding property defects? They come from the seller's disclosure notice. So guys, this is really just simple math. If you're doing a forensic accounting of a real estate transaction, and you know that misrepresentations about property defects is the problem, and then you go search for the document that has the most representations about property conditions, it's really pretty simple if you think about it that way. So that's in a very simple, superly simplistic way to think about it. That's why the seller's disclosure notice is the most important document when it comes to risk mitigation when you're representing a seller. It's just, if you're going to go fishing, where are you going to go fishing? You're going to go fishing where the most fish are. It's as simple as that. The most representations regarding property conditions is found in the seller's disclosure notice. And that's why it's the most dangerous document. It's just math. Think about how many representations there are on the seller's representation list. Obviously in Texas, we have different versions of the form, but if you think about how many representations are on there, and you just do some super simple math, let's just say that there is 100 representations on the seller's disclosure notice. And then you do the number of transactions in Texas on an annual basis, which is roughly 420,000 transactions in the state of Texas. Multiply 420,000 times 100. And then you apply an error rate, which is really low, of 1%. And if you just do that math, you go, oh, wow, that's a lot of mistaken representations that are being provided to buyers. And again, that 1% is probably low. But if you just do the math on that, you go, wow, that's a lot of potential misrepresentations. So if you really want to geek out and nerd out on it, you could do stuff like that, and you could see that, you know, there's a real potential for problem with the seller's disclosure notice. And in a nutshell, that's why it's so dadgum important. So what do? I'm going to give you another hypothetical here shortly that will be the first takeaway. And that's, how do we deal with the seller's disclosure notice? I think it's best to see it through another hypothetical that we're going to compare to money tree. So let's do, oh man, I got to speed up. Let's do that hypothetical right now. Here's our hypothetical. You have a buyer and a seller, listing agent, listing broker, inspector. In the transaction, the seller's disclosure notice says no to previous roof repairs. Again, the seller is saying no to previous roof repairs. The buyer moves in, lives in the house for some period of time, and then something weird happens here in Texas. It rains. And when it rains, the roof leaks like a sieve, and the buyer calls out somebody to come fix the roof, and the roofing company says, oh, we've been here before. We've been to this house before, and we told your previous owner that he should have done X, Y, and Z to address this roof, and the seller didn't do it. You'll be stunned how many times I've heard that exact story. Somehow they find out that there was a problem that wasn't disclosed, either through something like that or a nosy neighbor, a Gladys Kravitz, if you will, who tells them that the seller had that problem. Well, then what does our buyer do? Calls a lawyer. Lawyer says, hey, let's sue that seller. Let's sue that listing broker. Let's sue your own agent, and let's sue the inspector for not catching it. Again, unfortunately, Blackburn Properties was the listing agent on that, and they do something smart. They hire me and sit down with me and say, hey, this is crazy. Get me out of this mess. And I say, okay, here's what we're going to do. And what are we going to do, guys? I'm going to make the money tree argument. I'm going to go back to the judge and I'm going to argue money tree exactly like I did for our dumb hypothetical. What does that mean? I'm going to say blah, 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 just like I did in money tree. So I'm going to be in front of a judge and I'm going to have this screen up right here. And then in most of our courtrooms now, we have multiple monitors. So I'm going to have this one up exactly like this. And then on another monitor, I'm going to have up this. And I'm going to argue money tree. And then I'm going to make some arguments based on the language in the disclosure notice. And we can think smart people like Lori and other folks who do this for the other forms for these arguments. So what is at the core of the money tree argument? Judge, if there's a misrepresentation, the misrepresentation was the seller's, not my client, Blackburn Properties. So I'm going to argue money tree, and then I'm going to pivot and I'm going to look at this and I'm going to say, Judge, let's look at this document. Let's look at the language on this seller's disclosure notice. And it's going to prove to you, Judge, that my client didn't make the misrepresentation, that if there is a misrepresentation, it was the seller, not the broker. So what am I going to start with? I'm from West Texas, guys. I grew up in Midland. I very, very much believe in KISS when I try lawsuits. Keep it simple, stupid. So what am I going to start with if I'm going to argue KISS, which I promise you, I do it just like this. Some of my clients that are on this webinar have seen me make this argument. They can tell you I'm arguing it just exactly like this. I say, Judge, the first thing I say is, Judge, what's this thing called? And I pause dramatically just like that. What's this thing called? I repeat myself. Pause again. Judge, this thing is called the seller's disclosure notice. Notice, Judge, it doesn't say the seller's and Blackburn Properties disclosure notice. It says the seller's disclosure notice. So, Judge, if there was a lie, who lied? And Judge, if that doesn't convince you, let's look at something else. Judge, let's look at the first sentence. This notice is a disclosure of seller's knowledge. Judge, what does this not say? Again, it doesn't say this is a notice from Blackburn Properties. It says it's a notice from the seller. At the core, what am I arguing? Money tree. It's the exact same thing as money tree. Judge, if there was a problem, the problem is the seller's problem, not my client's problem, which is the listing broker. And guys, I've made this argument and it sounds like a total winner. I've made this argument hundreds of times, right? It sounds like a complete no-brainer and I should win because it's so true. Well, here's the problem. As soon as I make that argument and the judge is nodding his head, so yeah, I get it, Blackburn. You don't have to treat me like a dummy. I get it. Sit down, shut up. And then the other side gets up, and here's the problem. The other side gets up and says, Judge, that's real cute from Blackburn, but that's ignoring the facts. And then the other side, which is the buyer, right? Or the seller, whoever wants to keep my client in the lawsuit, the buyer's lawyer or the seller's lawyer gets up and says something like the following. Well, Judge, that's just not true. The listing agent sat down with my client and actually filled it out together. Or the listing agent actually filled this out for the seller. Or the listing agent did blah. Or the listing agent did X. Or the listing agent did Y. The core of the argument, because they understand that I'm correct, that whoever made the representation has to live with it. So what they do is they make some argument, doesn't really matter what it is, that the listing agent participated in some form or fashion and getting the disclosure notice filled out. And if they can't make that argument, then they pivot and make an argument that the listing agent failed to ensure it was done correctly, which frankly is not good enough, but it works, unfortunately, a lot of time. So what they're trying to do is, if I can do this, they're trying to hook somehow the listing agent into the disclosure notice because they have to, because that's where the lie is coming from. So they have to make it the lie of the seller and the listing agent / listing brokerage. And that's where the rub is. So what's our first takeaway? Our first takeaway, and it's our most important takeaway, and it may be our only takeaway due to time, but our first takeaway is don't do anything that allows the buyer or the seller to argue that this is your disclosure notice. In other words, don't fill it out. For goodness sakes, don't fill it out for your seller. I tell people tell me all the time, Bo, I know how to do this better than the seller does. So it's part of my service to sellers. I sit down with them and I actually fill it out with them. And I say, okay, hey, no worries. I'll make more money that way in the long term. So don't go ahead. But if you insist on doing that, I want you at the very top, I want you to take a pen and I want you to write seller and then write in your name. And they look at me and they go, well, why would I do that? Because if you're sitting down with them and helping them fill it out, it's the exact same thing. So just go ahead and write your name in there. And then please write your broker's name in there too, because you're putting them on the hook as well. So our first takeaway is don't do anything to make it your disclosure notice. So how do you do that from a practical perspective? Well, there's 50 different ways to do it. But the key parts is making sure that you have a system in place where you're getting them the notice, they're filling it out on their own, and you're not physically present when they're filling it out. Money tree, right? I said money tree specifically was designed to help illustrate the point. Who was present when the lie happened? Well, it was the seller and the buyer. So you want to take that concept and make sure that you incorporate that into how you get your disclosure notices filled out. And this is a good time. Lori mentioned I might do a little plug for Seller Shield. I obviously have known this truth for a long time. And this is one of the core benefits of Seller Shield is we protect the agent by having the seller fill out their disclosure notice using our process instead of you sitting there with them. And yeah, that's definitely a plug, and I apologize for that. But that's why we developed it. We didn't just do that to just out of the kindness of our hearts. We did that because we knew it was a benefit for brokers to have sellers filling out their disclosure notice on our platform instead of sitting there with an agent do it. Okay, so that's our first takeaway. And like I said, we may only have one takeaway with time. Oh, I'm way over. Lori, do you want me to kind of keep going, or should we pause and take some questions?
Let's pause. I've got 3 good questions that have come in,
cool.
And I think you can address those quickly. You can hear me, right?
Yes, I hear you fine.
Okay. First quick question is, what is the statute of limitations on these types of cases?
2 and 4. I don't know if you can see that. 2 and 4. There's 2 different statute of limitations. The shortest one is 2 years, and that's for like DTPA negligence. The longest one is 4 years. So if you're worried about how long can somebody sue after a transaction, generally speaking, it's 4 years plus some additional time for what we call the discovery period. But generally speaking, it's 2 and 4 years.
I think this next one might be a quick question. It may not be. Okay, so I'm the listing agent. I'm not helping my seller at all. Should I review it? If I see it and I see that something is answered incorrectly, or if I know it's wrong, what do I do? Great question. And you're right, Lori. Honestly, that's like a 50-minute conversation. I'm going to give you the super short version that I can. First of all, reasonable minds differ on that. In fact, my partner, my mentor, Boone Almanza, he completely disagrees with me. So I think reasonable minds can differ on this, but I tell agents, review it for completeness, not accuracy. In other words, you look at it
and you make sure that it's been completely answered, but you don't grade it. In other words, you don't look at it and go, well, this one's wrong, and send it back and make sure that they get it right. If you grade it for accuracy, then I think you're writing your name on it. I think it's the same effect. Now, Boone Almanza will tell you that by grading it for accuracy, that you're improving the process and that you're avoiding claims that way. And I can't disagree with that, but I think the legislature makes it very clear that this is the seller's duty to get it, to fill it out, and it's their job to make it right. I don't think it's the agent's job to make it right. And if you do grade it for accuracy, I think you're taking on extra risk that you don't need to.
The next question, this also may be a 50-minute, if you can sum it up in 2 minutes, is the scenario where you're talking about the seller, any scenario that you've used. A lot of times we get the question, and we got it today, I'm the agent and I'm the seller, and I did list the property through my broker. Can you address that for a moment as far as liability and disclosures?
Absolutely. There's a couple of things there. First is just a basic kind of general protection. Make sure if you're going to list your own property, talk to your broker and make sure you have coverage, E&O coverage, because a lot of policies exclude agent-owned listings from coverage. So you could be entering into a transaction where you have no protection, which you certainly don't want to do that. So that's, I think, the first piece of advice I always give agents when they're thinking about selling their own property. Many insurance policies exclude that from coverage. And why? Hopefully you're asking yourself, well, why would they do that? Well, the risk is higher and they don't want to take that risk on. Why is the risk higher? The things that we just talked about. The seller is the one making representations. And if you can't separate the seller from the agent, then you have more potential liability.
So Bo, along the lines of helping or not helping the seller fill it out, the review for completeness versus accuracy, how do you advise your clients, the agents, to deal with their clients, the sellers, when they're getting questions? You've given the seller the disclosure, maybe even you signed them up for Seller Shield, but yet that seller is calling you asking for help.
Great question. I get that all the time. For those of you who are Seinfeld fans, you'll hopefully appreciate that. There's an episode where Kramer pretends like he couldn't hear people when they were calling him. I would not recommend that. If you get a call from your seller with a question, I think it's your duty to answer it to the best of your ability. You know, they are paying you to be their agent, and if you can help them, you have a duty to help them. However, that doesn't mean you should give them legal advice. And many of the questions regarding how to properly fill out the disclosure notice require a legal interpretation. Not all of them. Like somebody calls you and asks you, what the heck is a French drain? Well, you don't have to be a lawyer to answer that. You know, tell them a French drain is X. And I recommend that you go to Wikipedia and find out what a French drain is in Wikipedia, and it'll tell you, right? That doesn't take legal advice. But if they call you and ask you a question like that, well, I think you got a duty to answer it. Now, if they call you and say, hey, I live next to a battery manufacturing plant that emits blah, 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 and some of those hazards are falling onto my property, do I need to disclose that? You shouldn't answer that question. That's the kind of question you need to go, I think you need actual expert advice on that, and I would recommend you contact a lawyer. And let me help you. Here's a lawyer that I think might be able to assist you in answering that question. And you give them, you know, 1, 2, or 3 lawyers that might be able to assist. Does that make sense, Lori?
Yeah. So I'm going to try and combine 2 questions that I think might have the same answer. Either I have a seller who's never lived in the property and absolutely does not want to fill it out. They don't fit into an exception though. Or I have a seller that I know outright lied on the seller's disclosure notice. They told me they weren't going to answer it properly because they thought that it would stigmatize the property, something to that effect. How, as an agent, should you approach those situations?
Good question. On the first one, Doesn't matter whether they've lived in there. The statute absolutely could exempt sellers who've never lived in the property or haven't lived in it for some period of time. We get this question all the time. And the statute is really clear. It's still their duty. They only have to disclose what they know. They don't have to go and research the answer and give a factually correct answer to every single question. They don't have to do that. They just have to disclose what they know. And then a buyer has to do due diligence and figure it out. So whether they've lived there or not, completely irrelevant to their duty to disclose. And you shouldn't, because we see this in leasing all the time, where agents have been the leasing agent for a property for a number of years. And the seller goes, well, you know more than I do. You've been there. I hadn't been there in 10 years. Doesn't matter. The seller still has the duty. Your second question was, what do I do if I get a disclosure notice that I know is wrong? And see, this is kind of where Boone and Bo differ. I would say that if you're doing what I tell you to do, you wouldn't know, because all you did is you looked at it for completeness, not accuracy. What Boone would say is, Bo, you're ignoring the reality. And this does happen where agents see them and they see that something is wrong and they can't sit silent. And I go, yeah, that's right. If you see something and you know it's wrong, you have a duty to address it with your seller and or the buyer if the seller won't fix it. So if you get something you know is wrong, then you need to do something about it.
Okay. Sorry, I'm multitasking.
No, please do.
We have about 2 minutes left. This question, I think, is for Seller Shield, the product. It's talking about the 2-year protection versus the 3-year protection. Is that an option on Seller Shield?
Yeah, we have 1, 2, and 3 years. Which should I buy? You know, it's just general risk mitigation. We have a 3-year product because there's a 4-year statute of limitations. It's a little more expensive than the 2, and the 2 is a little more expensive than the 1. It's just a question of how much protection do you want to have? You know, obviously I'm horribly conflicted to ask that question too, because I make more money on the 3-year. But it's just normal insurance. Do I want, and by the way, we're not insurance. I can't say we're insurance. So please, we're not insurance, but it's the same concept. How much protection do I want to have? And I'll leave it at that.
Okay. In the few seconds, I guess we have left, we'll go over just a little bit, but we try not to. I know we've all got other things we need to do. I did promise that we talk about COVID-19 for a moment. And Bo, if you wouldn't mind maybe starting it off just real briefly, the issue that we're hearing is somebody, and usually it's the seller or somebody in that household, has tested positive, or they think they've been exposed, or they have symptoms, any of those. What is the agent's requirement to disclose that, and or the seller's requirement to disclose
absolutely.
that?
I'm happy to chime in. First of all, I want to compliment you, Lori, and your agency. You have taken a position on this, and I just want to compare that to my committee. We have not. So I think you guys deserve credit for getting out and being a leader and taking a position on it. Because to be honest, and I know, because you and I have talked about this, I know that you guys have some reservations about taking any position on it because it's challenging. When we get forced into a position like this where we have to comment, when we frankly don't know, we don't know. I mean, we know better than most people, but we're not perfect. We don't have the exact right answer. So I want to compliment you guys for taking a position. The position that Texas Realtors has taken, which I believe is the correct one, is that there is a duty to disclose if you know of a positive test by someone that's living in the house. That is the position, I believe, Lori, correct me if I'm wrong, that Texas Realtors has taken. And I understand why they have. I think it's the prudent thing to do. I think it's the safe thing to do. Does that come with some real potential issues? You bet. I had a client who immediately contacted me when we put the word out on what Texas Realtors' position is and regarding privacy and, HIPAA. Doesn't HIPAA potentially exempt a seller from disclosing? Maybe. It might. I'll tell you the truth. I don't think so. but it hasn't been litigated. We don't know how that's going to turn out. Again, we're not perfect. We're doing the best we can in a very, very, very imperfect situation. And again, that's why I complimented Lori on taking a position, because again, we didn't. The broker lawyer committee has sat silent on this, and it's not our job to give legal advice, so we never would. But I think I agree with the position that Texas Realtors has taken.
And let me add to that, one of the reasons for that was specifically to COVID-19. As realtors, as professionals, we want to help reduce the spread of the virus. And so if there's any knowledge by anyone about a positive test or exposure, we thought that it was more prudent to help reduce that risk in that situation.
Well said.
I think at this point, Bo, we do need to wrap up. We really do appreciate you being here today. I think we're going to end up scheduling a part 2, maybe later in the year. I've been asked on here if we can continue this on this morning, but we don't have time for that. And as you said, some of these questions have their own 50-minute answers, and we could get into the weeds on some of them. But this was a perfect overview. For those of you that feel like you didn't get your question answered or have something more specific, please feel free to call the hotline, 1-800-873-9155. Don't everybody call at once. The hotline attorneys, we only have 3 to 4 on. But do call the hotline with additional questions, whether on seller's disclosure or COVID-19. Make sure that you go to the texasrealestate.com website to see our COVID-19 page, where we've got the information on disclosure and other COVID-19 issues. Bo Blackburn, thank you so much for being here. We will do this again sometime.
Thank you for having me. Loved it.
Thanks, everybody. Oh, and we will post this to our website later today. You will be able to go back and view it again.
Thanks, guys.